a lot of tension. Generally, there is a high degree of political intolerance, and many times the rule of law is under test. So whatever we are seeing right now should be seen within that context, because Uganda, to a large extent, is yet to come to terms with itself. We do not seem to appreciate the necessity sometimes for peaceful coexistence. Sometimes we don't see the necessity, or sometimes we seem to give way a lot of room to rivalry, political rivalry, business rivalry, family rivalry. So we see that a lot during the pre-election year, as different political actors start competing for the political space.
And okay, how does this look like for our country? You know, we have been seeing it's also going on in different media houses, you know, abroad. But how do you think this portrays our country?
Of course, it portrays an ugly image. It portrays a nation that still has to come to terms with itself, but also a nation which is yet to nurture the values that we should all be yearning for, the democratic values, human rights values, and also the necessity to compete peacefully, and also as much as possible to give room to dissenting views. So what we normally see is there is a tendency for those who hold power to abuse it. There is a tendency for those who in most cases are vulnerable to be abused, and as such that portrays a very ugly picture. And by the way, that has been a pattern ever since we adopted the new constitution 1995 and the elections thereafter. If you look at the elections in 1996, 2001, 2011, 2006, 2016, 2021, they have all been characterized by ugly incidents of arbitrary arrests, ugly incidents of hate speech, ugly incidents of disappearances. We used not have a phenomena of disappearances. It used to be a feature very common in South America, but even here, since the 2021 election, we now even have a feature of disappearances. We even have those arrests, occasioned by people in drones, people being kept in places which are not gazetted. So, and even freedom of expression, association, and assembly coming under a lot of, under a lot of tension. So, it is ugly, but on the whole, it speaks volumes about politics in a third world country like Uganda.
Okay. And what legal and human rights implications does the prolonged detention have?
First of all, detentions by their very nature are an abuse of fundamental rights. Because as we all know, everyone is entitled to a speedy and public hearing. Which necessitates that a person's fate must be determined in reasonable time. When someone is accused or suspected of having committed a crime, it is imperative on the powers that be that a speedy trial takes place. Now, of course, putting aside a speedy trial, we are even talking about arbitrary detention. Arbitrary detention itself has no space or has no room in a civilized community. So when that happens already, that is a transgression of people's fundamental rights, but also a breach of the rules of the game. Now, when you talk about prolonged detention, that in itself is a manifestation of an abuse of the rule of law, because there should never be such a situation where someone's fate is not determined, where someone is held in a place which is not gazetted, because by law a person charged with a criminal offense must be detained in a place which is lawfully gazetted.
Yes.
So when you are held in a place which is not lawfully gazetted, that already is an abuse of your rights. So prolonged detentions have no room whatsoever in a civilized society. That's why increasingly we have been speaking out against case backlog.
Yes.
That even in a proper legal process, people's fate must be determined. Unfortunately, in Uganda, we do not have a legal framework within which a time limit is spelled out for one to be detained once is remanded. You see, if you are brought before a judicial officer,
yes,
and you are charged and your case is mentioned, and you are remanded to prison, there is no time limit within which that trial must take place and be completed. That's why you have cases of people staying in detention for 10 years, 5 years, 7 years without their cases having been completed. And that in itself is a fallacy, but also an abuse of people's individual rights.
And what do you think could be causing this prolonged detention? Is it a gap in the system? What could be the issue here?
There are systemic weaknesses, but there are also institutional weaknesses. Systemic in the sense that procedurally, there have not been efforts to streamline such. Because when I say there is no legal framework within which a trial must be completed, that's systemic weakness. But again, when I talk about a trial taking too long, and sometimes a person even being forgotten. The other day, someone was found in prison having stayed there for 20 years, was actually forgotten.
Wow.
Forgotten. Now that is an institutional weakness. Now that is due to many factors. One of the factors may be the what you may call the investigative machinery. We have weaknesses in the investigative system. They are not well resourced, they are not well trained, and many times they cannot do their job in a record time. So there are weaknesses in the investigative machinery. There are also weaknesses in the prosecutorial, we call it prosecutorial system, meaning that those who are supposed to bring files before magistrates also have challenges. Until recently, we had very few state attorneys. We had very few state attorneys who would read the file, because it takes time for you to read a file and decide whether actually there is evidence for that person to be brought before court.
Yes.
And that's the role of what we call state attorneys. And there were very few, and they were not even well remunerated. So again, in that prosecutorial system, there are weaknesses. Then when you come to the courts themselves, they were, until recently, we had few courts, few judicial officers. They were ill-resourced, and therefore they were not also in position to dispose of cases in good time.
Yes.
But put aside some of the cases which come under serious concern or scrutiny are normally politicized cases where there is politics at play. And that means that there are also situations where we have political interference, which also leads to undue delay.
Yes.
So again, there are a number of factors that actually can be attributed to the failures, both systemic and the institutional.
So we saw that the Supreme Court had a ruling earlier to see that civilians are not charged in the military courts. However, what does the Supreme Court signify for Uganda's legal system?
The court ruling?
Yes.
Again, for many of us, we celebrated and were overjoyed by the Supreme Court ruling. Because for a long time, we have always denounced trials of civilians in military courts all over the world.
Yes.
The military justice system is very different from the civilian justice system, and we have always considered a complete misnomer for someone of a civilian nature to be brought before a military court martial. And of course, when the Supreme Court ruled, of course, it gave us a sense of relief. To a large extent, as you recall, the Constitutional Court had earlier, 8 years before, actually ruled that trial of civilians in military courts was unconstitutional. Now, when the Supreme Court reaffirmed this position and ordered that all files before the court-martial should be brought before civilian courts, one expected that, this would be done without undue delay.
Exactly.
So on one hand, we of course we celebrated, but on the other hand, again, going back to the systemic and the institutional weaknesses, we are still experiencing further delays. The reason is the DPP, who ordinarily, of course, initiates this criminal proceeding, was ill prepared for what actually happened. So the systems are not in place. Actually, I've overheard that those files before the military court martials had no record whatsoever. There is no information, because these people are arbitrarily, arrested, dumped there, remanded at will. So there's no information. So even this designing a system of how to handle those cases has been a nightmare for the DPP. Now, let alone the fact that even their fate cannot be determined, because increasingly they still have to determine which is the court of competent jurisdiction. We talk about a court of competent jurisdiction. Now, a court of competent jurisdiction is actually a construct, call it a construct, of the crime that you committed. So if it's a capital offense or it is a minor offense, then either you go before a magistrate court or you go before a high court. Now, you still have to determine that. So that is, again, the reason why there have been all these delays. And up to today, we are yet to see these people in court.
And what do you think the system can do better to see that there's no backlog of such cases? You mentioned someone was in detention rather, for 20 years, which is quite unfortunate. How do you think the system can be improved to see to it that such cases don't happen?
For a start, as a way of working towards improvement, these courts must be independent. The legal system must be independent. It must also be respected. One of the challenges I alluded to earlier is political interference and the politicization of cases. That can also be a major contributing factor towards the delays we are talking about. When, the powers that be, order from above, makes it difficult for some of these cases to be fast-tracked. That's one challenge. The other one has to do with innovation. Of late, there are a number of innovations that the judiciary has come up with, and I think increasingly the judiciary is struggling with awareness of these innovations. For example, we have talked about case backlog. We have had cases of people overstaying in prison. Of recent, the judiciary has come up with what is called plea bargain. Now, if a person committed a crime, was convicted or has not been convicted, but is willing to plead guilty, there can be a negotiation with the state so that that person's sentence is determined. And that can actually be a very important measure towards reducing backlog. The other innovation is what is called alternative dispute resolution. Even in this Besigye case, you have had many people calling for forgiveness, reconciliation, asking the president to exercise his power of pardon and clemency. There are all those. Now, alternative dispute resolution is also another important mechanism through which you can resolve cases without taking the full course of the law. The law, the legal procedures are very intricate, and they lead to bureaucratic approaches. So alternative dispute resolution, like negotiation, conciliation, all these help to fast track case dispute resolution. So it's possible to reduce the case backlog and reduce the prolonged detention through some of these innovations. But as I said, these are recent innovations. The judiciary is piloting them, and the people need to know and be aware, because sometimes they may not be invoked, largely because you need consent from the parties involved.
Yes.
You need consent, for example, from the victim. You need consent from the offender. You need an appreciation of the mediator.
Yes.
And when those three are not in play, you may not be able to invoke that procedure. So understanding and appreciating these innovations and mechanisms becomes important. But overall, I think it is a good way to go.
Okay, and we are seeing that there is also an option of bail. In this particular situation, do you think that bail is something that can actually be considered?
For a long time, our organization, the Foundation for Human Rights Initiative, has been campaigning for respect to the right to bail.
Yes.
Bail is a guarantee. We call it a constitutional guarantee. We also call it a procedural guarantee for fairness and justice. Because, you know, in Uganda, like many other Commonwealth countries, we have what is called the presumption of innocence. When somebody is accused of having committed a crime, doesn't mean he's a criminal.
Exactly.
That person has to get the benefit of doubt.
Of doubt, yes.
And that means that given the weaknesses we have talked about, it is also helpful at some stage in the legal process for the courts to consider the necessity of granting bail. Now, bail is something which is very contentious. As you know, the president has always been, uncomfortable with bail. He has always spoken out against bail. He has always accused the judiciary of granting bail and made it look very ugly and dirty. But I want to assure you, bail is an important constitutional and procedural guarantee, because ideally, given the weaknesses, but also the fact that I am still innocent until proven guilty,
yes.
I should be given the benefit of the doubt. For example, if the investigations are still continuing, you know, in an ideal situation, in a society where there is respect for rule of law and human rights, you do not arrest before you investigate.
Okay.
Here,
it's a different
you
case.
arrest before you investigate. A mere presumption, a mere assumption that someone has committed a crime is enough to be arrested.
Yes.
And now that creates a lot of problem. You arrest, you have not investigated. Even when you have investigated, you don't have enough evidence. So you bring this person and then he or she is remanded. That is very unfair. You know what that actually means to his freedom or her freedom? Do you know what that actually means to that person's plight? You know that person's plight?
Yes.
It is terrible. So the judicial officer should be given room and should be able to exercise a discretion to grant bail or not. And once bail is granted, it does not mean, and I think this is very important to our political elites, granting you bail does not amount to an acquittal.
Yes.
Because there is always that assumption that once somebody has been granted bail, then he's free. He's not free. Investigations are continuing, the trial is continuing, but he's being given the benefit of doubt to do whatever he does while all this goes on. Now, once somebody has been given bail, there are certain conditions that have to be met. First of all, and actually they are very stiff. And there is also an affirmation by the offender that he or she will actually report whenever called upon. So bail is an important safeguard. And also bond, not only bail. Actually, we should also be talking about police bond. You recall last year the president in his address also again castigated the grant of police bond. Now, again, this shows you that we are yet to come to terms with some of the benefits of some of these measures, because granting a police bond is a very important relief. Do you know how many people are held at those police stations? The police stations are full and they're under very bad, poor conditions. So when you grant someone a bond, it doesn't actually mean that that person is free. It means that person is being investigated and should have the benefit while the process continues. So these guarantees overall should be promoted as a way, one, of decongesting prisons, two, upholding rights of offenders. 3, ensuring harmony and stability. Because can you imagine someone without just cause makes an accusation that you have committed a crime when you haven't actually committed it. Maybe because of business rivalry, social rivalry, and then all of a sudden you are arrested, dumped in
no
the police
evidence,
station,
no proof,
and you find yourself in prison and 5 years. Do you know that level of miscarriage of justice? It's actually incredible. So I think we need to uphold these values in order to promote the rights of people.
Okay, we are going for a short commercial break, but do stay tuned. We are discussing something very, very interesting. We are looking at the impact of democracy and human rights, and definitely you would want to still stay with us here on our second half. I'm here with Dr. Livingston Ssewannyana, the Executive Director of Foundation for Human Rights, who is giving us more information, especially regarding what's happening right now. We are going for a short commercial break, but stay tuned. We'll be right back.
This is Church of Uganda Family TV. Enriching lives. Regulated by the Uganda Communications Commission. This is Church of Uganda Family TV. Enriching lives. Regulated by the Uganda Communications Commission. This is Church of Uganda Family TV. Enriching lives. Regulated by the Uganda Communications Commission.
Okay, welcome back. You are still watching Issues at Hand, and of course I'm here with Dr. Livingston Ssewannyana, the Executive Director of Foundation for Human Rights, and we are discussing the impact on democracy and human rights, even as we delve into what is currently happening in the country. I know that you are aware of what is happening with the detentions, and of course we also have alleged abductions happening here and there, but we are going to discuss more of that. Now, Dr. Livingston, we were here talking about bonds and bails, and there are assumptions that, you know what, they're different. Just briefly, I want you to give us an explanation if in this particular case, is bail even, can bail be granted in this particular case? Because you told me there are capital offenses and petty crimes as well. So for this situation, can bail be granted in this case?
Yeah, bail can be granted in all cases, provided the conditions have been met. Normally, judicial officers will impose conditions. In capital offenses, the conditions are more stiff and more stringent because of the nature and the gravity of the offense. But in petty crimes, they are much simpler. However, the Constitution also made provision for what we call mandatory bail.
Okay.
Now, mandatory bail in petty offenses is actually 60 days.
Okay.
60 days. If you stay in custody for 60 days, having committed a crime, and your trial is not ongoing, you are entitled automatically to grant of bail. It's called mandatory bail.
Okay.
If you committed a capital offense and you have spent 180 days in custody without your hearing taking place, you are entitled to mandatory bail.
Okay.
So there are two types of bail. The mandatory bail provided for by the Constitution,
Yes.
and the normal bail, which is a discretion of the judicial officer.
Okay, that's so. In this case, it would be very, very viable, and bail should have been granted by now, I believe.
Bail can, first of all, for bail to be granted, one, it must be applied for.
Oh, okay.
You have to apply for bail.
Okay.
It's not upon the judicial officer to give you bail. You have to apply for bail.
Okay.
2, you must be eligible to be granted bail. 3, you must fulfill the conditions of grant of bail. And 4,
Wow.
the judicial officer has a discretion to grant your bail. Yeah.
Okay, that's quite interesting. And if you say you have to be eligible, what does this eligibility entail?
Eligible means that not only do you fulfill the conditions, but there must not be such a risk that if we granted you bail, would definitely pose a danger to society. You imagine a serial killer.
Oh, yes.
If a serial killer applied for bail, again, I wouldn't consider that person eligible because he or she is a danger to society.
Yeah.
So eligibility now means that you qualify, and the qualification may be you might be a first offender, you might be a person of advanced health or advanced age. You know, you may be a person of social standing. You know,
Yes.
Here is someone of social standing, a minister, a member of parliament, and granting bail to such a person would not be such a risk.
Yeah.
So that is what we mean by eligibility.
Okay. Okay. Now, we have heard of a few abductions allegedly. What is your take on that? Especially now that we're in the election season, there is this detention happening, we are seeing abductions here and there. Well, what is your take on that?
It in many ways is a return to the dark past. As you know, ever since the NRM came to power, the understanding was things like abductions, arbitrary arrests would be a feature of the past.
Yes.
And if you recall, during Idi Amin's time, people would be arrested, abducted, and would go missing. To the extent that in 1974, President Idi Amin issued a decree called the Missing Persons Decree.
Wow.
And under that decree, if you got missing for 3 years, then the state was no longer responsible for you.
Wow.
Under the Missing Persons Decree,
You're forgotten.
government would not be responsible whether you died or. But I think there was an understanding. It also had some political ramifications, although many times we view it only in the context of rights. Remember that there were people fighting his government, and during that time there were people running out into exile to join forces to fight him.
Yes.
So when he passed that decree, the understanding that he shouldn't be held responsible for saboteurs and those who were undermining his government.
Yeah.
But in terms of rights, it spoke about a poor human rights record.
Yes.
Now that should be a phenomenon of the past because that decree was actually repealed. Now during the NRM, our expectation under the 10-point program, there would be absolute respect for rights, democracy, and rule of law.
Yes.
Now for us to be experiencing these arbitrary arrests and detentions is actually unfortunate. I would call it unfortunate because today the legal system should be working properly.
Yeah.
The law enforcement officers are well trained. They know the rights of offenders and so on.
Yes.
They know the legal processes. So there should be no room whatsoever. The fact that we are still experiencing this speaks to the necessity for us to exercise some degree of political intolerance. They are largely politicized arrests.
Yeah.
They are mainly people who are standing up against the regime. And as such, they have actually, it's very important, they have a chilling effect on society.
Yeah.
Because one, if the abductions arrests take place, then those who would ordinarily engage in political discourse would fear.
Yeah.
Secondly, it becomes also a high risk for anyone to engage in some form of political, political discourse. So it has a chilling effect on society.
Yes, yes.
And makes society, to a large extent, a bit less participatory in the running of their affairs.
That's true.
So we should actually denounce them at the earliest possible opportunity, because they definitely don't speak well of a regime that should be upholding rights, democracy, and rule of law.
Yes. And of course, what do you think these abductions would have, especially what impact will it cause for a free and fair election in our country? Oh,
speaking about elections, again, they have a far-reaching impact. One, as I have said, society withdraws.
Yeah.
And you know very well that this is the time when we should be experiencing heightened political activity.
Indeed.
Do you know, we are yet to know whether Ugandans actually went out to check their names.
That is true. And actually,
the numbers a high degree of adamance. People are adamant about
that
this.
Is true.
Of course, we are experiencing, according to the roadmap, the electoral roadmap, that soon Ugandans should be engaged in campaigns, offering themselves as candidates.
Yes.
And campaigns should be taking place. Now, do you expect people to turn out in large numbers to listen to potential candidates when there is a fear of being arrested and abducted?
No.
Again, you can see the impact that it can have.
Yes.
And then ultimately, when elections are held, whether the Ugandans would still go out and vote in large numbers.
That's true.
So I think it is a phenomena that must be addressed at an early stage, because it has a far-reaching impact on our current political discourse.
Okay, and what role do you think the security agencies play in these incidents? What do you think they should be doing better, to give accountability?
Security agencies, by their very nature, are mandated to ensure law and order, one, and of course ensure that people are safe, society is safe. They have to exercise a high degree of discipline, and they must be seen to be accountable to the population, because all these institutions are established for the sake of upholding your rights, protecting you. Actually, Article 20 of the Constitution is very clear. The state shall guarantee respect for the rights of citizens. And Article 221 is even much clearer. It says all state security agencies in the exercise of their functions must observe and adhere to human rights principles.
Yes.
Which means in the execution of their work, they must uphold rights of citizens. So they have a duty in ensuring law and order to protect society, but also protect individuals from arbitrary arrests and imprisonment. So I think we should call upon them to exercise that responsibility. But I'm also aware that they undergo a lot of intense training.
Yes.
And they even are aware of these rights and procedures. In fact, the former Inspector General of Police, if you recall, issued guidelines on law enforcement. The necessity for law enforcement officers to stick and adhere to the guidelines. And the guidelines were speaking nothing else, upholding rights.
Okay. And then also, what immediate actions would you recommend for ensuring justice, especially tailored for opposition detainees, opposition figures in this case? Now, when a person is detained or arrested, he must have or she must have recourse to law, to the legal process.
which means it's important that he gets or she gets legal representation.
Yeah.
Must have access to a lawyer. So institutions, political parties should always ensure that they have lawyers at hand. But also we as NGOs, we also run legal aid schemes. We have also lawyers who can represent these people without cost.
Yes.
We do. So they must have recourse to legal assistance and seek interpretation of their rights before court of law. Now, when you are subjected to arbitrary detention, your lawyer is supposed to apply for what is called a right of habeas corpus. Under Article 44 of the Constitution, it is one of those rights that cannot be restricted and is guaranteed. The right to habeas corpus. Now, right to habeas corpus means you go to court and seek an order demanding government to produce the person.
Yeah.
And then his or her fate is now legally determined. So recourse to legal assistance is important in these situations when people are arbitrarily arrested, detained, and sometimes when they go missing.
Okay. And now, even as we wind up, it's been quite short but interesting. What message do you have for Ugandans concerned about the state of democracy and political freedoms in the country?
One, of course, they are entitled to these rights. They are entitled to these freedoms that they should take as given.
Yeah.
They should not compromise the enjoyment of these rights by always being reluctant to pursue their cause. I think it's important, and that's why in my sojourners, or they call in my travels and in my work, I have appreciated some countries like Nigeria, where I've been. I even stayed for a year.
Yes.
Nigerians would never allow anyone to abuse them.
Yes.
A Nigerian, once there is an abuse, will run to court and will vehemently defend his rights. Ugandans, we are too fearful, and many times we seem to be disconnected. We always fear to advance our rights. We always fear to fight for what belongs to us. So one way of promoting democracy, rule of law, and freedom is never to allow your rights to be sacrificed at the expense of political expedience. So Ugandans must stand up for their rights. They must stand up to be counted. They must also work towards redressing the imbalances in society, because much of what we witness is actually imbalances in society. The fact that when it comes to access to opportunities, when to access to services, there is a lot of imbalance. We must work towards reducing inequalities, imbalances, and ensuring that freedom is available to all. Unless we are all free, none is free.
Yes. Well, okay. Thank you, Dr. Livingston. And of course, we are here with the Executive Director of Foundation for Human Rights. We have been discussing democracy, human rights, and rule of law. A lot have been said here. But of course, I do want to thank you for being here with us on the show. Thank you for giving us more insight, a better understanding, even with everything that has been happening, even as we await for the court proceedings that are happening today. I understand that there is a sitting that is going to happen today. And yes, we just have to wait and see what will come out of that. And of course, we are hoping for positivity only. But we have come to the end of the show. Thank you for staying tuned to Church of Uganda Family TV. Issues at hand. I am Hope Nyongereza, and I wish you a blessed day.
This is Church of Uganda Family TV.